My name is Jennifer Olmsted. I am the Senior Director of Governance and Operations here at the San Diego County Medical Society. In partnership with the Doctors Company, I would like to welcome you to tonight's webinar on understanding the anatomy of a lawsuit. And now I'd like to introduce Kathleen Stillwell. Kathleen?
I am the Senior Patient Safety Risk Manager with the Doctors Company, and I'm also thrilled to tell you that since September, I am also now the Designated Risk Manager for San Diego County. I have Orange County, San Diego County, Riverside, San Bernardino, and counts in Los Angeles County. But if you are with the Doctors Company and you ever need any assistance or support, my contact information will also be at the end of this program. I want to take a moment to introduce Jehan Jayakumar because he is an extraordinary attorney and a human being that is in my top 10 list of people that I can work with in my work. He's founding partner of Carlson and Jayakumar, where he practices in all aspects of employment law, healthcare law, and related litigation. The firm also does medical board litigation, and I refer Doctors Company callers who have questions about business contracts or health, labor, employment to this firm because they are an endorsed business partner of San Diego County Medical Society, also of OCMA Medical Association and Los Angeles County Medical Association. So I'm really happy to have someone as distinguished with so much experience. And thank you, Jehan, for joining us tonight. The objectives tonight are to explain the process of a malpractice legal action in California, to identify what steps you should take if you are named as a defendant, and to identify 3 areas of your office practice that you could focus on to decrease malpractice potential liability. I always like to start with an inspiration, and I took my inspiration for this program from Thomas Jefferson, 3rd President of the United States. He said, "Ignorance of the law is no excuse." And so as we progress into this evening, let me show you what a 90-day notice can look like. A California medical negligence action begins like this. And that's my note on the left side: do not ignore the mail, a 90-day notice of intent. And so sometimes it can come and look pretty innocuous. And also people can send in pro per a notice of intent that just says, this is my 90-day notice of intent, and I intend to represent myself in an action against you. And that is equally as effective. And so with that, I'm going to turn it over to Jehan and ask you, Jehan, to comment on what I just said about in pro per. Is there any difference? Is it just as important as the 90-day notice from a law firm?
Yeah, Kathleen, great question, and thanks for the kind introduction. A notice from an in pro per, meaning a party representing himself or herself, should be taken as seriously as one from an attorney. Number one, it has the same legal effect, and number two, there's no stopping that individual, that former patient or current patient, from hiring an attorney before the filing of the lawsuit, or during the lawsuit, or even just before trial. And so, just because they're in pro per doesn't mean that that it won't go anywhere or that it won't go to trial just because they're representing themselves. It should be taken, as seriously as a claim from a lawyer. So with that, I will segue into our first topic, which has to do with the notice to the physician. Under California law, a patient is required to give the physician written notice of their intent to sue. And it's one of the few areas where in a private dispute, meaning not involving a governmental actor, that a party is required to give notice before they file a lawsuit. In most situations, whether it's employment or personal injury or a breach of contract, typically under California law, no notice is required. You can just file your lawsuit, and that is the notice. But when it comes to medical malpractice, California Civil Code requires that the patient give you notice at least 90 days before they file the lawsuit. And that 90 days, it tolls or pauses the statute of limitations during that time. So as soon as you get that notice from the patient, whether they're in pro per or represented by an attorney, the first thing you should do is give it to your malpractice carrier and get the ball rolling. You don't want to wait until you get notice of the actual lawsuit being filed, because when you learn about the lawsuit, you may have been filed for some time. You may have been served a few days or a week prior before you actually learn about it, and then you have less time to respond. And of course, your insurance carrier, whoever they are, and again, this is true for whether it's an automobile insurance carrier or a business policy, the carriers require time to process your claim, to figure out whether it's covered, to appoint counsel. That always takes time, and so you don't want to notify your carrier on the last possible day. You want to give them time to do what they need to do to make sure you're covered, to get your attorney in place, get that attorney in contact with you, and then get the responsive pleading on file with the court before it's too late. And so that kind of brings up the question, which was also one of the questions we got before the seminar, which is, what is the statute of limitations in California? Typically, for a medical malpractice claim, it's 1 year from the date of the injury or from the date the injury should have been discovered, but no more than 3 years. There is an exception for patients who are under 6 years old. In that case, they have 3 years or until their age of 8, whichever is longer. If you're over 6, then it's the same as if you're an adult. That being said, don't take the statute of limitations as a get out of jail free card. If you get a notice of intent, even if you think that it's not timely that the statute is run, you still want to tender it and to your insurance carrier and take that notice, seriously and take the appropriate action. Don't be your own lawyer. As they often say, someone who acts as their own lawyer as a fool for a client. Get that tendered to your carrier, get them to appoint an attorney, and get that attorney on board as soon as possible. In certain cases, the patient alleges delayed discovery. In other words, they say, "Look, judge, look, court. There's no way I could have known about the injury until 1 or 2 years after the injury occurred, and here's why." And in those cases, in that case of delayed discovery, the statute of limitations is extended, and it can go up to 3 years. There's also a longer statute of limitations if there's some kind of fraud by the physician to cover up the injury. Perhaps the records have been falsified, or there's been some other malfeasance by the doctor to cover up the injury. In that case, the statute of limitations is also extended. But again, don't take that statute of limitations as a hard number. Take it as sort of a soft number. And so whenever you get that notice, tender it and take it as assume that the claim is timely, and let your lawyer figure out if it's timely or not, and let them, if it is untimely, let him or her challenge that in court. Now, many times the physician, and we hear about this all the time, the physician gets a call from a very friendly lawyer. And look, we all appear to be friendly, but just, a friendly call from a lawyer who wants to ask just a few questions. You have no obligation to speak to a lawyer, whether or not they represent a current patient. If they're relevant, you have no obligation to speak to them. So if you do get a call from a lawyer or a letter from a lawyer, again, you want to either contact your insurance carrier or your attorney as soon as possible. Do not speak to them, because anything, as they say, on the crime shows, in the Miranda warning, anything you say can be used against you. And so, for that reason, you never want to talk to a lawyer that calls you on the phone, unless it's me, in which case you can talk to me. So, when might you first learn that the patient is contemplating legal action? Typically, it could be a request from the patient or from their lawyer asking for a copy of their file. And it's important that if you do get that request, that you respond and get the records to the patient or their lawyer within 15 days of receiving the written request. And you want to make sure that record is complete. You don't want to hold anything back. And so if you make sure it has the intake paperwork, any examination, any notes, bills, informed consent, make sure they get a complete record of everything they signed, kind of from an admin perspective, again, meaning the intake forms and insurance records and informed consent, and then from sort of the medical side, which would be the patient actual, the notes of the visit, labs, and so on. Okay. In certain situations, family members may be able to obtain copies of records on behalf of their loved one. For example, if the patient's deceased, under certain situations, if if they have a power of attorney for a living person, they can get those records. If you do get that request, you're not sure, be sure to consult with legal counsel before you respond. So the important thing when dealing with legal matters is what you do before you actually learn about it, right? So you want to make sure you have policies and practices in place so your team at your office knows what to do. What do we do if we get a call from a lawyer? What do we do if we get a legal request for records? What do we do if we get notice of intent to sue? Or what if we get served with a copy of a lawsuit? Have those plans and have that training done ahead of time. So if and when it does happen, that your staff is trained and knows what to do, knows who they should be notifying, knows what needs to be done, and so it doesn't just get thrown in the inbox or on by the side of the photocopier and just kind of forgotten. You want to make sure that your staff is trained on what to do, and that may also involve taking some actions if the patient is a current patient. We need to determine, can we continue care? Do we need to end care or transfer care to someone else? Those are all discussions that need to be had. But again, the key is that you have your staff trained ahead of time on what to do when this occurs. So when a patient threatens to sue, there's 4 things they have to prove, right, in order to prevail on a malpractice action. They have to prove that you had a duty to do something for the patient. That's fairly easy to do because as a physician, you obviously have obligations to the patient. You have to make sure you exercise reasonable care, comply with the standard of care in treating the patient. That's fairly easy. The difficulty is they then must prove, usually through an expert witness, that you breached that duty. You did something that you shouldn't have done, or you didn't do something that you should have done, or you did it in a careless way. And then they must prove that your breach of that duty caused the patient some type of harm, right? It could be physical harm, it could be emotional harm, and then they finally must prove that the damage can be quantified in dollars, right? And again, typically will require an expert witness or two to prove things like if they had lost wages, if they had emotional distress or pain and suffering. Those are all things that an expert can speak to and that the patient would have to prove if they try to prevail in a court of law. The damages are the injuries that are suffered as a result of the negligence of the defendant, and that's generally true in every kind of negligence case or tort case, whether it's a physician malpractice case or some other kind of personal injury case, right? And so there's 2 categories of damages, very broadly speaking: economic damages, which are not capped by MICRA, and those are things like medical expenses, lost wages, which is sort of back pay. Future lost wages, future medical expenses, lost earnings, those can all be quantified and are not capped by MICRA. What MICRA does cap is the non-economic damages. That includes past, present, future pain and suffering, loss of consortium, things of that nature. And so MICRA is not the be-all and end-all. The patient can recover these economic damages that in certain cases could be quite high and could exceed the MICRA cap.
Thank you very much, Jehan. I'm gonna transition to this slide because I want to tell you a little bit about, in backing up, why patients file lawsuits. The Doctors Company has been in business over 50 years, and we now have over 100,000 physicians in our company, and we do a lot of studying and analysis of closed claims since the first year to see what are people suing for now, what are the issues, what are the frequency and severity issues. And I wanted to share with you that what we see is why patients sue is on this claim. And the biggest one I put in red: they feel that no one cares or nobody listened to them, that they felt that they are unhappy with the attitude of people. Sometimes people feel entitled. Well, I paid you a lot of money for this per surgery, and especially when we get into things that are elective cosmetic and plastic surgeries, and I didn't get the nose I wanted, and I don't have the breasts that I planned for, and I wanted to look like the Housewives of Beverly Hills, and I don't. And I didn't get answers when I asked questions, or they just are dissatisfied with the treatment. But what we see at the Doctors Company is that it's often not the patient at all who is unhappy. and feels entitled and wants revenge or retaliation, it's someone in the family circle. It could be a spouse, an adult child, or an adult friend. It can be a cousin, a parent. And they say, this shouldn't have happened. You need to sue because you should get money for this. And when attorneys take these cases, you don't pay any money up front to a plaintiff attorney. They take it on a commission basis based on a percentage of what you win in an award. And the doctor's company knows that a malpractice lawsuit life cycle is anywhere from the short of 24 months, which is rare to be even through a case in 24 months, to 60 months. And if you have an appeal, it can even go longer. So what you're talking about is this attorney, the plaintiff attorney, has to fund everything on the front end. And if they're planning to go to court, if they think they're going to have a trial, they're going to have to get experts. They may have to pay $50,000 to $120,000 out of their pocket. And so they have to be very careful about taking cases that aren't going to bring money. I can tell you that the doctor's companies, our statistic is 80% of our cases are closed with no payment to anybody. Of the 20% that are left, out of that 20%, less than 5% go to trial. And of the ones that go to trial, we lose less than 1%. The ones that are left are settled. Why? Mostly because there's not documentation to support the standard of care, even if it was a great doctor. We are not interested in settling, and we don't do arbitration. Now, mediation is a little different, and I'm not going to get into the legal terms, but what we see is that our doctors do very well, and we go all the way, and we spend the money to go all the way to take you to a defense verdict or to be dismissed from the case. But your relationship and communication with the patient is going to be one of the biggest factors in these reasons that we see people suing. I want to show you from a study that we did on 20,000 claims, and this is from our internal data. Communication issues are the third most common contributing factor. And of those, you can see the number one was clinical judgment, number two, technical skill. Do you see communication? And it was communication between provider and patient or patient's family. That's where the big hit is. And think about that when you don't talk to their family or you don't want to talk to their family. Think about, is this a good place to say, I'm not talking to you? And among providers, 13%. That means doctors to doctors, consultants and referrals. Doctors aren't talking to each other. We found that as a contributing factor in 13% of these 20,000 claims. Electronic tools, that was primarily the EHR. And then, of course, teletransmission, virtual visits, and other, that was insignificant. So what we see are the top risks in the medical office practice. And I only put this on here to show you because we are evaluating and doing risk assessments of practices throughout the years. And over 30 years of medical office risk assessments, I wanted you to see the top issues we find for recommendations. Documentation isn't adequate. There's no there's none or inadequate lab and test tracking. Medication management. A lot of meds are not given in some offices, but some offices, infusion centers, in a lot of offices, people are coming in getting injections and getting treatment. But look at informed consent. And I want to say something here that you'll hear about later as well. Informed consent is not a piece of paper, a consent that the patient signs. That's not informed consent. And when you get into a legal situation, the standard of care is show us the informed consent. And showing them a piece of paper that the patient agreed to this is not informed consent. That's just a piece of paper. Informed consent is what the clinician, whether it's an APP or a physician or a dentist, who spoke to the patient and said, I want to explain the most common risks, complications, alternative treatments, including none. You might want to go into it, bleeding, scarring, infection, injury to adjacent structures, whatever you say, explain to patient, allowed to ask questions. And best in class is to put patient responded in quotation marks, I agree and I want the procedure. That's your golden ticket to prove informed consent. And you can make a smart key on your EHR, and all you have to do is fill in the name of the procedure on that, and that puts it into your medical record. And if you need any further help with that, if you're with the doctor's company, you can call me and I can help you with that. We have language that our legal counsel has prepared. Appointment management, why is that on there? Why? Because appointment management is one of the big contributing problems for people who don't have a good experience with a practice. It's hard to get an appointment. There are no-shows. We don't send them letters. We call them. No, 2 calls and then a letter if there's no shows. You have to have documentation for that. Speaking of that, we go right to documentation. And I'm going to just make a few comments here, and then I'm going to turn it back to Jay Hahn. Medical malpractice claims, they're won or lost based on the quality of your medical record. Your medical record is your silent witness. You can't possibly write everything you do, or you would only be documenting all day long on one patient. So figure out the most salient comments. I do a lot of medical record review, and here's one of the common recommendations I make. Stop writing narrative paragraphs and telling stories. Just make bullets. Make bullets. Make it short and sweet bullets. Poor documentation or vague, incomplete, altered records will impeach the medical record and your credibility. So let me just say, if you're using an EHR and you get a letter from an attorney that the patient's suing you, go look at your record, say, oh, wait, I know I told him this and that. I guess I didn't document it. Do not touch the record. Don't put it in, please, because the EHR has a date stamp in the metadata for the person who signed in on their password. Every keystroke, every backspace, everything you delete will all show. And now in malpractice, both the plaintiff and the defense attorney will request a metadata report of the patient's record. And if it shows that you added or altered something at a time that wasn't contemporaneous to the treatment, that impeaches the record. And you will have a very difficult time if you're going to be able to defend yourself. Let me give you an example, though. A week later, you realized, oh, I had a call on Saturday night and I forgot to put it in the record. You can tell your office staff, hey, I talked to Kathleen on Saturday night and I told her to do this and that. And I called in a prescription and told her to go to the emergency room. I forgot to put a note in the record. Your staff can go in and put addendum to record. Dr. Smith asked me to document Saturday night date conversation with patient regarding, and you put it in. You call it out that it's an addendum. An addendum is different than a late entry. A late entry is within 24 to 48 hours. An addendum is something that's more than 48 hours after. And it's okay to put it in. We can't remember everything. I had a doctor that went on vacation and he called me from Switzerland. He said, I forgot to put an important note in. And I said, just send an email to your office manager and tell her to put it in and say that you called from Switzerland because you forgot to put the note in. Human error is allowed. Claims are often not filed until years after an event, and especially with minors, I want to say that. But even when something comes up, they might want your records. You weren't party to the claim, but the attorney will say, I'm going to get all the records. Who are all the physicians who treated you in the last 10 years? The same thing that happens when you have an auto accident or if you have a work comp claim. They will say, list all the doctors you've seen within the last 10 or 15 years, and we want to get the records. Now, I do want to tell you, we used to in California have no specific medical record retention. It was keep them as long as you can. We recommended 7 to 10 years. But in 2024, the California came out with now the record retention is 7 years. That's great if you have manual records, but all of the records that are on EHR now are forever, and you're paying more for HIPAA compliance cloud storage. And I'm encouraging people with EHR to say, talk to your EHR and see what can you do about reducing your stored records on a cloud, because you don't need to keep them. And if you keep them, then you're going to have to produce them. So I'm just saying the rule now is 7 years. Expert witnesses will follow the care you gave and testify if it was appropriate. These are the common gaps. I'm not going to go through all of these. I'm just going to point out a couple of things because you are going to have access to these slides. But gaps in the story and not being able to follow a chain of events well. Think about that. You told the patient to do something. You don't know if they ever did it. The biggest problem I see is you refer me to a cardiologist and then you never check to see if I went. And I didn't go. And then I die of a heart attack and my family sues. Well, you know what? You're going to be sued. And how are you going to explain? Well, we told her to go, but we don't make it part of our business to see if they followed up. Did you refer me to a specific cardiologist? And did you call there and say, I'm referring Kathleen Stillwell to your office? Here's her number if she doesn't call. And you don't call, your office staff calls. You have to be able to show that you were intentional, not just giving a reference. If you say go to your primary care, if you are a specialist, and get a referral to a blank, and then please let our office know within 2 weeks or within 30 days. And if they don't, you do have any way to follow up with them? But the next time they come, do you look and say, hey, I saw you 6 months ago and I referred you to a specialist. Did you go? And if they didn't, then say patient denied following through with referral, recommended again, rationale, and write something about it. This is my last slide about what should be documented when, out of ordinary situations. Patient non-adherence and non-compliance. That is critical because that's one of the 5 acceptable reasons you can dismiss a patient, and you can't just dismiss somebody in the middle of care, but you have to document non-adherence. And your network contracts say if you have an HMO patient, you have to go to the HMO and get permission to dismiss them. And they're going to say, give me 3 examples of non-adherence or 3 documentations. Or if it was bad behavior, give me 3 documentations. If you see Medi-Cal patients, the county Medi-Cal provider will ask the same thing. And of course, failure to follow advice of a consult, that could be, did they get it or not? And if they didn't, why didn't they? And your staff can say, called the patient stated in quotation marks, I decided I'm not going to a cardiologist. Then they tell you, and then you don't have to call me. You say, you can have a letter. And I help with letters all day long, every day. Perplexing symptoms or outcomes. One of the best things is to get a second opinion. Send them to someone for a second opinion. With that, I'm going to turn it back over and get some legal commentary on poor documentation from our legal eagle. Jehan?
Sure. Yeah. Thanks, Kathleen. And I understand that you may feel that documentation is sort of the bane of your practice, much like a lawyer might feel like billing their time in increments is kind of the bane of our practice. But it's obviously one of the most important pieces of evidence that'll be evaluated by an attorney in deciding whether to bring a case or not. It'll also be evaluated by an expert witness, either on your side or the other side, to determine whether or not there was a breach of the duty of care. And so those records oftentimes will make or break your case. And so, good documentation could really save your bacon. And so take a little bit of extra time, even though you may not enjoy it, and make sure your documentation is, as bulletproof as you can reasonably make it.
And let me add, because I mentioned informed consent earlier, when I review records and see surgical reports that begin with, after obtaining informed consent, I selected number 5 scalpel. That isn't where you document you did informed consent. Then if you're in a litigation, Jehan, what does that look like? How do you defend that?
Yeah, it's not easy to defend. It definitely puts your attorney behind the 8 ball when you have that. And so you want to make sure that you follow the tips that we're giving you today in your documentation.
And this exam note before a catastrophic spinal infection is because we had a case that I reviewed where the catastrophic spinal infection, which was the man never walked again, but the note about it was written after the notice of intent was received from the attorney. How does that play in the defense of that kind of a case, Jehan?
Yeah, it makes it, again, that exam note could sort of be your get out of jail free card. And one more thing I wanted to add, Kathleen, was that, many times malpractice cases are litigated twice, right? They're litigated once in civil court or an arbitration, on the malpractice side. And then if there is a settlement or a verdict, oftentimes, if it's over $30,000, it has to be reported to the board. And you may have a second case involving that same patient, that same interaction involving the Medical Board of California, where they're seeking to discipline your license for that same incident that the patient has already sued you on. And so, again, the documentation is going to be looked at by perhaps 2 or 3 or 4 attorneys, and then many experts in possibly as many as 2 different legal matters. And so it really is the most important piece of evidence that we're going to deal with in these cases.
You use the word arbitration, so I want to throw out a comment, because more than 10 years ago, California passed a law that said anything that was settled in arbitration in malpractice has to be, anything in arbitration, it has to be published on a public website. At that point, the doctor's company and some other very worthy competitors, including CAP MPT, which mandated arbitration, and they could audit every 3 years that you did it. And they immediately dropped arbitration. We dropped it. We don't do it. And if you are still using arbitration, you don't want to be involved with that. In healthcare, the only people that are doing arbitration is Kaiser. And Kaiser doesn't, because it's a closed business and an entity of itself. I was told that they don't have to publish their arbitration decisions and issues on the public website. So if you have any questions about that, ask your carrier and be aware. You don't want to be persistent on that. I want to talk a moment about laboratory diagnostic test and consult tracking. It is the referrals made for the consult or an order for the test. It is one of the most basic critical functions of the medical office. You get a lot of tests, and you have to make sure somebody is tracking. Are they getting the test done? Are you getting the results? If the same thing is happen if it's a consult. So it's a consult or a test. And I just want to stress 70% of patient diagnoses depend on lab results. And you have people who aren't going to the lab and they aren't getting it done. And I know we had a case recently that I had a doctor call me and he said, I told the patient that they had a condition and it was some kind of autoimmune, and he had some very special selective tests they wanted done. And he said the patient never went and got it. Now they're in the hospital in critical care. And I'm being asked why I didn't run those tests. And I said, I did. I said, when did you tell them to get the tests? He said, I don't know, I have to look in the record. I said, well, have your office manager look it up and call me back. She called me back. She said, it was over 6 months ago that we told the patient to get the test. And I said, nobody followed up. Nobody checked with the patient. This was critical labs. That doesn't sound critical. Jehan, if there's a lawsuit, how do you explain that?
In that case, you definitely try to throw the patient under the bus and put the onus on the patient to follow our care instructions. And so you can apportion fault among more than one party. And that's something we might try to do in that case, is to apportion some fault to the patient in failing to follow the care instructions.
They're going to look at you and say, why didn't you follow up? Establish a system of active tracking. So this is a question for you to ask your practice. Do we rely on alerts and reports sent to the physician's inbox for information? The portals now are very abused by many patients, and doctors say, I can't, even my in-basket is overflowing, and I can only get to it once every 2 weeks. And this is it's not a mailbox like Gmail. And you don't want your patients sending you all these messages if you're using email, which by the way, it's a HIPAA violation, federal and state HIPAA, if it's not encrypted. And if you're texting and it's not encrypted. And just so you're aware, in litigation, the plaintiff and defense attorneys also get now the metadata, not just for the EHR, for your patient's records, but they get it from your cell phone. If you're using your personal cell phone or a work office cell phone for texting patients or having conversations with other doctors about patients, be prepared. That's going to all come out and they're going to get it. And I have doctors say, well, it won't work, Kathleen, because I'm going to run my car and drive it over and smash my phone and it'll be gone forever. I said, no, I'm sorry. Metadata is like herpes. It's forever. You can't get rid of it. They don't come to get your phone. They go to your phone carrier and they will get the electronic footprint of your phone. Do not have your office staff using their personal phones. I've lost track of how many doctors call me and say, I have a subpoena for the metadata on my cell phone and I don't want them to have it. I said, is there something on there you don't want somebody to see? Yeah, I don't want my wife to know about it. I don't want my girlfriend to know about it. I've got sexting, texting, jokes. I got stuff personal and private. I said, I understand that. If you are using a personal phone to talk to patients, to call and text with patients, not only is it a HIPAA violation if it's not encrypted, get yourself a burner phone and just call them and knock out the texting, because everything you text has to be printed, scanned and printed and put into the medical record. And if it's not in there, that also can impeach the medical record, because I'll tell you the patient will have it. So Jehan, if the doctor is texting and they never saved any of the texts, but the patient did, how's that going to play out in court?
Yeah, it's not going to look good for the doctor, right? And those texts are admissible in court, and they are oftentimes very damaging to the defendant, and really in any kind of case. And so, uh, definitely want to avoid texting or using unsecured, unencrypted methods to communicate with the patient.
And you might think, well, what's a HIPAA violation? It's $100 or $150. Did you know that it will be multiplied times the number of patients in the database for your practice? And you will be very quickly at a six-figure fine. The good thing is it can't exceed $1.5 million. Notifying patients of results. So I want to say this, they should get all results. Normal results, your staff can call and say, Dr. Jehan wanted me to call and let you know that your test results came back. Everything was within normal limits. They're in your portal if you want to look at them. And we'll see you in 3 months or 6 months or in a year. If it's abnormal results, they can't call and say your results were abnormal. Then it's doctor wanted me to call you, wants to schedule an appointment with you to go over your test results or the biopsy findings. Well, what was it? Was it not good? The doctor will have to speak with you about it. Some of those calls can be done on telehealth, or you can do it on a phone call, but only the provider should be giving that. The provider who is treating the patient. Have a system for critical value reporting or urgent consult findings. That's something that you want to also be looking at. And definitely never say to a patient, no news is good news. We only call you when something's wrong. Instead, encourage patients to always call if they've not heard from the office or received results from a test or a referral. And it's going to be depending, because maybe they can't get in to get the test for 30 days. So I didn't put a number in there, but generally, if you haven't heard from us within 2 weeks, call our office if it's lab tests. Some lab tests might take longer because the patient only has to remember theirs, but your staff, it will make it much easier on your staff to keep track of all of that if they are the ones that have it, the information, if the patient calls you. Now we're back to Jehan on a legal commentary. What about these missed lab results? Does it increase liability for the doctor?
Yeah, it definitely does. And again, in every lawsuit, you're gonna have attorneys and expert witnesses evaluating your performance. Did you order the correct tests and labs? Did you review those tests and labs in a timely fashion? And did you take the appropriate action after you viewed those results? Did you make the proper prescription or make the proper referral for follow-up care or for a return visit? And you're going to be Monday morning quarterback to death. And so you want to make sure that you do all that. Otherwise, you're going to be looking at increased liability. And so with that, it takes us over to informed consent, which we've discussed quite a bit. And in the interest of time, given our remaining time, I'll be somewhat brief here. Informed consent, it's more than a form. It's more than just saying, noting that you discuss the risks, benefits, and alternatives with the patient. You want to take the time to thoroughly talk to the patient about all the aspects of the proposed treatment plan, and not only what the risks and benefits are, but also if they have any specific concerns or specific risks that are specific to them, as opposed to the common risks that every patient has to go through. And to discuss those common serious risks with them, and if there's a complication to occur, what's going to happen. You want to avoid giving exaggerated reassurances like "Don't worry about a thing. I'm sure you won't have any problems." Basically, promises that you can't keep, right? So you want to definitely avoid that. Communication is probably the most important aspect of informed consent and really the communication techniques, right? Consider the patient's age, culture, education, perhaps there any kind of language barrier that may exist, and make sure the patient, more than anything, it's really psychological. That the patient is as comfortable as they possibly can be with the treatment plan, and allow the patient the opportunity to express any concerns or ask any questions that they may have. Of course, the informed consent form is obviously also very important, right? It's oftentimes it's one of those things where you don't really get credit if you have it, but you do get in a lot of trouble if you don't have it, And so it's one of those things where it's sort of like the bare minimum that you're expected to have, and so you want to make sure that you have a well drafted, consent form. A lot of insurance companies will assist you with that or will provide you with a form that they recommend for your practice. And usually those are drafted by their in-house counsel and can be used with with the patient. Um, and so uh, from a legal perspective, you want to make sure that you pay special attention to patient-specific risks, pay special attention to certain conditions or ailments or other environmental factors that may affect this patient more than it may affect other patients, and then discuss that with the patient, but also document that discussion to make sure that you sort of papered the record with what you've done to make sure that the patient is fully informed before they undergo the care.
And for those of you who are with the Doctors Company, and even if you're not, on our website, www.thedoctors.com, we have sample consents and they're available to anyone. And one of the things that I really like about our doctors' consents is you don't use check marks, patient's initial, because if you put a check mark or an X, that I understand this, X, what we find in litigation is people say, I didn't make that. I didn't make that. I didn't write that. I never did that. What's the difference, or why would it be better to have their initials there, Jahan?
Well, you definitely want to know who, if you're going back a year or two later, you want to know who said what, right? You want to know, you want to put a name or a witness in legal parlance to that particular event.
Thank you. I'm going to move quickly on appointment management because this is really to decrease incidents of patients being lost to follow-up, because that's what happens when we look at how many problems with appointment management. You want to provide a reminder to contact the patient if you couldn't reach them before. And if there's an emergency contact name on your records for the patient, remember that is not permission to speak to the emergency person about the patient's condition or why you're trying to get a hold of them. You can have your office staff call the emergency person and say, Kathleen listed you as an emergency contact. We're trying to reach her and the number's disconnected. Could you please get a call to her that it's very important to call our office? And they say, well, what's it about? What's going on? What happened? I'm sorry, we follow all federal and state privacy laws and we can't share any information. Kathleen has not signed an authorization to release any information. It's just, can you please have the patient contact us? No one should be relying on memory. I think that there's a lot of good electronic task reminders in the EHRs. Physicians should be notified if there's no-show patients, not just that the staff says, oh, well, these people didn't come, or this was the fourth one. I had today a doctor's office called me and said, this is the fifth no-show in a row. And I said, what did the doctor say? Well, we haven't told him yet. I said, did you tell him about the other four? No, they're just not on the schedule. I said, that's a mistake to the manager. I said, you need to be giving some heads up and also a letter. Again, 2 phone calls and then a letter to people. Legal perspective, what's the importance of a warm touch when scheduling?
Yeah, I mean, I think that warm touch is going to make sure the patient stays in communication with the doctor's office, and the better the communication, the more clear the communication, the less risk there is of a dispute, and the less risk there is of litigation.
And think about it. If someone calls you to remind you about something, you're thinking, gee, that was nice. They took the time to call and remind me. I didn't even think about that. Medication management, I'm going to just skip over a couple things and tell you what I see missing most often is that medications are not discontinued, just like problem lists don't get discontinued, they're changed. And we see very little in our review of medical records over-the-counter medications. And you really need to be asking about cannabis, vaping, not just smoking and alcohol anymore. Are you using any cannabis products? Do you do any vaping? Are you using any recreational drugs? People say no, and they just write patient declines, blank, blank, blank. But you need to ask, because there's a lot of things that patients are taking, and then they have some kind of bad outcome, and there's a lawsuit, and we find out everybody knew that the patient was doing this and doing that, but the doctor never asked. And then in depositions, the doctors say, we don't ask that. And then the experts say, why wouldn't you be asking that? That's a drug. Just because cannabis is legal doesn't mean you wouldn't ask. Just like over the counter. What are you using over the counter? So this is just about being good on that system. Jehan, what about the cures system? How important is it that they check that?
Yeah, I mean, you're not complying with the standard of care if you don't check cures. It's as simple as that, right? You failed your obligations as a physician if you don't check cures. Cures is often the evidence that's used not only in malpractice actions but also in board actions for things like overprescribing or in other kinds of board cases. And so, yeah, checking cures it's a bare minimum that they're going to look for. And so you want to make sure that you do that and document it. And so if there is a lawsuit, we can point to a piece of evidence that shows, hey, we checked yours. This is what it showed at the time. And so anything that happened after that is not really, can't be put on the doctor.
It's also helpful if you run the cures report and print it off, and the patient wants you to prescribe something, and you say, I'm not going to prescribe it because I ran your cures report, and trust me, these people know what that means. And you can see that you're getting scheduled drugs from several other physicians, so I'm not going to order anything. Also, I want to say for elective surgeries, especially plastic surgery, if we have any plastic surgeons, run a cures report before you even do the consult on the patient. I'm telling you, the calls I get from plastic surgeons and psychiatrists sounds like they're all seeing the same people. There's a lot of behavioral issues, and you want to know, are these people on drugs? Are they taking behavioral meds? Are they taking scheduled drugs? You want to know that before you agree to a surgery. So communication and documentation are key. I think now I have to have cultural linguistic competency. I'm not going to go through this. I can't get CME if I don't include that. So let's go to the best physician is the most ingenious inspirer of hope. Samuel Coleridge. That's who you are. You are the best physicians out there, and our APPs. I put you in that category. And you do inspire hope and well-being for people, and they trust you and they feel confident in you. And we hope that what you've heard tonight in a very quick overview of a lot of information will be useful for you as you avoid things that can be a problem if you do get into a litigation. And I would like to ask if we have, well, I will tell you the link. We have links for resources. This is all in the slides. The instructions to get CME credit are here. And you have to set up an account, and our activity code is 4156. If you need any assistance, my assistant, Maggie Lapointe, will help you. If you need anything from me, here is my email.
All right. Well, we do have quite a few questions that have come in. Several are along the same lines. How can we be held liable if patients are not following through on their referrals? How are we responsible if the patient completes a test? Why are we responsible for a patient having to complete a test or consult when they were told to do it at the time that they have a visit with us?
Yeah.
Well, can I make a response from the clinical point of view, and then you give the legal response? Please. Okay. From a clinical point of view, if I come to you and you tell me I need to see a specialist for something, You're the doctor. You understand my condition. I don't know. I don't understand what this problem is that you think I have. I'm not sure that I'm worried about or think it's important. How much information did you give me? So I'm just going to put it off, and I'm going to take my vacation. I'm going to take a trip, and I'm not thinking that it's going to hurt me if I don't and I delay it. But then what do? Do you just tell me to go, and you're saying check with your health plan network, get a referral, and you don't do any follow-up to see if I followed through? And if I do go and the doctor said, oh, she came and we saw her, you don't necessarily have to get the records, but what are the unintended consequences if they do nothing to even see if they followed that recommendation?
Yeah, and that's a great point, Kathleen. Obviously the physician can't be held to the standard of putting a gun to the patient's head, literally or figuratively, to ensure compliance with the recommendation. But certainly the doctor needs to be able to prove that they took reasonable measures to ensure that the patient complied. And so it's going to require more than just making that referral. You need to follow up with the patient, document those follow-up efforts, right, to make sure that to do what you can. So if the record shows that, hey, the office followed up several times with the patient to see if they would follow through, and the patient wouldn't comply, then you're probably in a pretty good spot and in a very defensible spot.
And it's really important to document it. And one thing is you can create a little form letter that says you were seen in our office on date. We referred you to Dr. So-and-so or to this specialist. Please contact our office once you have made an appointment. Just something that simple. Does that help to show that they made an effort to follow up, even in
Yeah,
advance?
definitely. And so hopefully you're using some kind of, secure electronic communication platform. Here in Orange County, my doctor uses my chart, and so all the communications are documented. And so the follow-up can be done through my chart and in our example here, and that could be used again in court, as a defense, should the patient bring an action.
Kathleen, should lab results actually be typed or incorporated into the clinical note, or is it just enough to document lab results from the date that they were reviewed and discussed?
I think that's a matter of the preference of the physician. We don't tell you how to practice medicine. We just say, make sure it's clear in the review of the record that it was reviewed, results were reviewed and discussed. The results are in there. You don't have to reiterate it and mark them all down. If something was high, or you say, well, platelets were, 100,000, that's low. Maybe if labs were all fine, platelets were a bit low, or they're going to send to a hematologist, something. You don't even have to say what it was. You can just say it was low if you're going to refer someone to a hematologist.
And can you elaborate on encrypted text and emails and how to set that up?
You have to have a system. And let me say that if you're not using encryption, and you should be very mindful of this, if you have a release or a consent signed by the patient that they know it's not encrypted and they agree to it, and we have a sample consent for online communications, email and texting, that if the patient signs it and they initial each line, then you won't have a problem with a HIPAA violation. But so either get encryption and you have to pay for that system, or get a consent signed that says we have a consent signed that they understand that it is not privileged, and that it's not confidential. If you need that, you can send me an email. You want to chime in?
I would just add that in today's day and age, I think juries and judges and arbitrators expect doctors to be using, at least in Southern California where we practice, maybe not in rural Alaska, but here in Southern California, that judges and juries and doctors expect doctors to be using technology that's sort of current technology, and to be using encrypted methods to communicate electronically with patients. And I think if you're not doing that, it's not going to look good, optically.
Thank you to all of our attendees who took time out of their day to join us this evening. Lastly, if you are a physician, not yet a member of the Medical Society, please consider visiting our website located at sdcms.org. You can find out more information about becoming a member, the various benefits that we do offer, and you can easily join online in less than 5 minutes. So thank you, everybody, and I hope you all have a great evening.